Yeah, so like I said, my name is Brad Hayes. I manage the impact assessment section at the DNR. We are the place where EcoCat is housed and where you would do this consultation process. Um, it's currently called impact assessment section. That could change in the next year or two because it's state government and they change our titles and our things all the time. So these are the acts that establish the requirements for consultation. The ones that are outlined are bolded: the Illinois Natural Area Preservation Act, the Illinois Endangered Species Protection Act, and the Interagency Wetland Policy Act are probably the ones that you guys most often would trigger a consultation. We also do have the state agency Historic Resource Preservation Act and the SHPO that is housed in the DNR. But typically you would go through a different process to coordinate with those. Although those are handled in my office, they're for DNR projects, so we wouldn't necessarily interact through those acts with most developers. But the Illinois Natural Area Preservation Act and specifically the Illinois Endangered Species Act requires that consultation occur with state agencies and local governments. Go to the next. And these are the administrative rules that define those processes. Illinois Admin Code Part 1075 in particular is how the consultations are meant to be done. You should also note that this is currently being reviewed at JCAR. It's been decades worth of revisions for some minor changes, but hopefully in the near future, there'll be some minor changes to the administrative rules, but currently as they stand, this is what they are. As you can see here, these are the actions that require review. Any construction, land management, or other activity that are authorized, funded, or performed by agencies of state and local governments that will result in a change to the existing environmental conditions that may impact endangered or threatened species or protected natural areas. And again, you would do this process. You would begin that process by initiating consultation online through EcoCat, which stands for the Ecological Compliance Assessment Tool. I just shared this. There's a lot of layers turned off, but this is essentially what our program on our end would look like. So if you were to submit a project, those pink buffers are where we have known occurrences of endangered species in Illinois. So if your project falls within those buffers, that would be considered a hit, and we would probably provide some kind of response. It may be a response that we had no concerns, or but generally, I'm just trying to give you. I think I cover that a little later, but this is generally what you're going to what we see on our end. I thought it'd be useful for everyone to get an idea of kind of what we're looking at. These are the types of projects we review. Generally, anything that's permitted in Illinois. It can go from energy production, transportation, commercial and residential development. It kind of covers the gamut. But the key takeaway is any project that's authorized, funded, or performed by a state agency or local government is technically required to submit an EcoCat. There are exemptions built into EcoCat. I list them here. Mowing are some of the main ones anyway. Mowing and maintenance within right of ways, routine maintenance of existing roads, anything with a department approved management plan, routine lawn care, changings and zonings from a developed or from a commercial or from an undeveloped zoning to a commercial or industrial or residential purpose. But all these exemptions depend on the fact that there won't be any, there's no protected natural areas or endangered species in the area. So again, these exemptions, like a lot of exemptions, it's really hard. How would you know that there's not one of these resources there unless you talk to us? The only way to talk to us is to go through the consultation process. So I usually recommend that most people, the easiest answer is just to submit a consultation. We also do coordination with the feds on their permits. Typically, again, this wouldn't, if you had a permit, a 404 permit, or we're going through any kind of NEPA process, we would take a look at that through the federal process and provide comments to any of it. And we try to make sure we coordinate that well with the state or the local government agency, but essentially we're going to get a comment on this from the federal side if there's a federal permit. So I just wanted to make sure everyone's aware, even if you did not talk to us and you think, okay, we've gone this far, if there is a federal permit, it'll probably be brought to our attention. We'll have a chance to comment there. And these are typically the results from, once you submit a project, it would go to and it would map itself on that map I showed earlier. If it hit one of those buffers, that would mean a project has a concerns identified. We would continue coordinating with the staff, other agencies, the project proponent, and the results would be, we could either request surveys or additional reviews. We can provide recommendations for seasonal work restrictions, alter the design, avoiding habitat areas, education, exclusionary practice, conservation practices, things like that. The key thing is with that mapping we brought up earlier, if a project falls outside that buffer, you would immediately get a response with us saying consultation is terminated. And that report that says that means you've done the consultation process. Typically, when you hit a buffer, we can provide a response that comes usually within a week or two. We are usually pretty quick about our turnaround. If there's not a lot of concerns or no real concerns on our end, we may just generate a response and send that back pretty quickly. We may have a couple of slight recommendations for conservation or to avoid impacts. The one most people are familiar with is winter tree removal to protect bats. That may be as simple as that. If it's a little more complicated or we have a lot of resources, it may take us a little longer, but we'll put together a little more a more technical response with maybe more recommendations. But again, our turnaround time is pretty good. I think anyway. We did look at some numbers for IDCEO grant turnaround, and we had, I think it was 95% of our responses were within 2 days. So for the most part, we're doing pretty good at getting these responses back. These are additional results that we could potentially offer. Worst case scenarios that we do have an endangered species, and because of the scope of the project, there's no way that we could avoid take. Take, defined by the Illinois Endangered Species Act, includes not only just killing the animal, but harm and harassment. So affecting a bird's nesting season would be considered a take. Causing, things have to move off the site, or even picking up and moving an animal is considered a take. So if we feel like there's no way we could avoid take by either a seasonal date restriction or any other kind of avoidance BMP, then we're going to recommend that you pursue an ITA. ITAs are handled by a different office within the department. And then the consultation part would be over, but we may work with the ITA program a little bit, but most of that would begin, you'd talk to another person in the department. The ITA process can be a little bit burdensome. It can take up to 6 months. There's a public notice process that goes along with that. So, plan accordingly. If your project, especially if you think there's any potential that an ITA may be required because you may know there are some species there, I would say, you want to get stuff to us at least 6 months in advance, depending on the scope of it. Those ITAs can take a little while. And just as a note too, per the Illinois Endangered Species Act, plants belong to the landowner. So we cannot do ITAs for plants. We do have a lot of listed plants, over 300 in Illinois. What we typically do is provide recommendations to avoid or to collect seeds or do something to try to conserve the species. But at the end of the day, all you need is a note from the property owner that they're allowing the plants to be taken and you're not violating any of the statutes. And just as our consultations on those are valid for 2 years. And this, I won't go through this in a lot of detail. I think these are available to everybody, but this is essentially the process. I think our program's a little dated, a little confusing. This is sort of kind of to help you get through the form you'd submit when you're submitting a consultation to us. But use that as a reference in the future. So this is the same kind of slide here. It's just sort of how we go through that process. And I think that's the end of that. Oh, nope, that's the location, sorry. Yes, and then this would be on you're in once you get to the final part of submitting your consultation. This is what you would see. You would draw a polygon around the project area, you'd submit that to us, and then again, then that's how you would start that process. The other statute that may affect you guys that goes through our office is the Interagency Wetland Policy Act of 1989. It's the state's wetland law with the stated goal of no net loss of wetlands in Illinois. But this statute does not apply to every project. This would only apply when their state is either performing the action. So this applies a lot to DOT or even the DNR. When we do some sort of construction project, we have to follow IWPA, but it also applies when there's state funding. So if you're getting any state grants, you may have to meet these requirements. You can go to the next slide. But this is the administrative rule that we follow for IWPA. It also has exemptions built in. It essentially, IWPA takes jurisdiction of all wetlands in Illinois. Any sort of activity that could affect the wetland, from tree removal to fill to alterations of drainage or hydrology, can be considered an impact of wetlands. There are exemptions for repair, maintenance, and conservation management, stuff like that. But again, we have to make that exemption call. You would just have to provide us with the information about the wetland impacts and what you're doing, and then we would make that call. Next slide. It's very similar to, if you're familiar with the Army Corps wetland requirements. The process is the same for delineation of wetlands. We allow mitigation on Army Corps sites. The mitigation is usually very similar. The big difference is we again take jurisdiction of all wetlands. Our reviews are valid for 3 years for these, which is slightly different than the actual T&E consultation, which can be a bit confusing. And our mitigation ratios can be a little bit different, but we try to work with the core ratios. Unless there's something that forces us to go a little higher, we try to make those match up the best we can. You're not doing it additional to the Corps requirements. So for example, if the Corps says you need 5 acres of mitigation and ours says you need 8 acres of mitigation, you would just get the 8 acres total, and that would cover the Corps and us. The other big difference is that I think often confuses people. The Corps talks in terms of temporary and permanent impacts. IWPA does not. It uses the terms minimal, significant, and destruction. Minimal, they're defined here as a loss of half an acre or less, or loss in less than half an acre, and does not affect the hydrology for more than 12 months. Significant is more than half, less than 2, and will affect the wetland, or does not alter the hydrology for more than 12 months. And destruction would be anything that falls outside of that. So essentially, destruction is a permanent impact. The other two can be considered more temporary usually. So those are essentially all the statutes that would work with through our program. The only other thing I thought I should mention too is we do have there's a fee associated with any consultation that's submitted as a local government. The state agencies do not pay a fee because we have agreements with these other agencies, so they don't pay fees. For example, if you are needing an NPDES permit and you submit as an IEPA review, there would be no fee. But if you're needing a consultation for a county or municipality and you choose a local government, there'll be a $125 fee. We also have an option for an information request. That is a $25 fee. And the goal of that would just be to provide you the hits without locations, but just for project planning purposes, so you know what may be in the area. And the other thing I thought might mention to everyone is that we have been for many years now, we've been trying to update our system. It's been quite the process. We are hoping in the next year or two to have a new EcoCat, something a little easier to use, something that will allow us to at least upload shape files and keep better track of projects than the system we have now. So, any questions?
Yeah, thanks, Brad. Really informative. Had a couple questions in the chat. First one, the do you know if there's folks, I guess in Kendall County, they have some folks are submitting these with a note that says not part of a 1075 consultation. And I guess sometimes it sounds like they're selecting this with maybe not a lot of evidence because it's a cheaper option.
Well, so the cheapest option would always be to submit as a consultation for a state agency. And so the way this was originally structured would be that we may look at the same project for every permit. So a county could have a permit, EPA could have a permit, the Corps could have a permit. We'd see this project 3 or 4 times. The reality is that doesn't often happen. Most of the time, what people will do is, assuming they'll say they need an MPDS permit, which would be the most common time they would coordinate with us, they would use that one review and share, that would be the review that's done. And the counties would accept that. Whoever else would need, that for their permit would accept that. So it's typically done once. And if they do it that way, there is no fee associated with it. The fee for an actual consultation would only apply to if you choose local government as the jurisdiction of the review. That $25, I think what they're doing is misunderstanding. They're not initiating consultation on that question 1 of the EcoCat form. They are choosing the third option, which should be for information purposes only. And it does state that on that question. So it is kind of clear that you're doing this for information, not to coordinate with us. And when they do that, we would never put eyes on that. Those just hit the system, and then you get a response, and we wouldn't review those ever.
Yeah, that's because applicants aren't always aware about what's required for EcoCat. And so they look at the choices of either the $25 fee or the $125 fee plus the administrative fee or whatever the state charges, that extra $1.27 or whatever it is. And they just click on the $25 one because it's the cheaper one. And then we have to tell them, no, you have to do a consultation, a part 1075. And then they go, oh. So if there's a way that the state could maybe clear that up on the application, that might help the average resident who doesn't really have to deal with EcoCat on a frequent basis.
We usually try to work with those people if they do contact us to try to be helpful with that. And we get that. Unfortunately, that webpage, it was built back in the early 2000s with code, and everyone who knows how to fix that has retired and gone on to better things than working for the state. And so when it breaks, it is really tough to get fixed. That's part of why we're trying to do the upgrades. And so there is nothing we can change at this point. It is what it is. But we do understand that for some groups, we have provided kind of an instructional how-to Word document or PDF. I don't know if I could share that with anybody if they were interested. Maybe they could share that with the applicants if that helps at all.
Unfortunately, people don't read that stuff because it's like 9 pages long, and that just isn't in their memory to remember there.
I think the simplest way would be to just state on question 1, you have to choose initiate consultation and not the other options, and maybe that would get them in the right direction.
Had a question from Marcus.
Yeah. So as part of our plat review process here in the city of Urbana, when somebody wanted to split a property or do something, we would send out that that proposed subdivision to all of the relevant agencies. In our land development code, that mentioned you might have to coordinate with IDNR for historic preservation or EcoCat, but we didn't list an IDNR contact. We had, when I started working here in 2016, we contacted our local soil and water district for that. And when we did, we actually sometimes got responses from the resource conservationist. So we've never directly contacted IDNR. We'd always been going through Soil and Water. And interestingly, when somebody complained and said, look, if I have to do an EcoCat, it's going to cost me $500. This was a few years ago. And when I asked the resource conservationist about this, he's like, yeah, for a private person, it's could be $500, but we'll waive that fee for locals. So when he would send me, he was actually sending me natural resource reviews as opposed to EcoCats, I think, and they didn't charge us. So this requirement for IDNR and there being an online thing or consultation is all brand new for me. And so since we are authorizing these projects, it sounds like we need to be contacting you all every time we do this, or every time, maybe not for parcel splits, but we are now, if somebody wants to develop a piece of land, even if it's already been split, we're making them apply for our development permit, which is then, you know, locals authorizing that. So who should we be coordinating with, and how? Is it a website? Is it?
Yes, it would be through EcoCat, through the DNR. Now the only natural resource review that I'm familiar with would have been something that goes through the DOT. I'm not sure what they're providing you. And if you want to share that with me, or if you could share me one of those, I could get back to you on, you know, through email with what the right process is and what they're sharing. The other thing, I'm wondering if they're just doing the federal review for you. Is that
this had like hydric soils in it, and it looked at endangered species and all that stuff.
Interesting.
Yeah,
well,
I'd
be happy to take a look at that, and we'll get it figured out for you.
I would just point out, Marcus, most of the civil engineers in town are already doing the EcoCat
on their own.
Yeah, so if you were to require that document to be submitted with an application, I would, because like Brad was saying, if it's in an area that's not covered by the hatch that he had on that map, that purple area,
right?
It does not take very long. Like they have a website, you just go on and punch in the address that you're at, and it will terminate the review within like 15 minutes. I think they said it takes about 15 minutes to fill it out, and I don't know if there's a fee for that. I would assume there is.
It all depends on the jurisdiction you choose. There's only going to be a fee if you choose it for information only, which is not a true consultation.
That's
the whole fee process was a mess, but if you choose local government, it's always going to be $125. I will just say this like this, whoever who you guys interpret this how you would like. No one knows who or for what jurisdiction these are sent in for. If there would ever be if there's ever a point where an EPA permit would be needed or something, it would not be wrong to submit that as an EPA project and get a review and not pay a fee. If, however, it depends on how you guys want to handle that. But if you choose a local government as the jurisdiction, there will always be a $125 fee.
Brad, is there a way for a local government to know if somebody should be submitting a report from you? Like, do we have access to that shapefile map that says, oh, this project's in the blob, I should be expecting to get one?
We are very protective of our endangered species information.
I understand.
Yeah. So now that being said, you can enter into a license agreement with the state to get that information. So you could have access to that information.
Okay.
You would just have to with our database folks and get that information.
Sure.
So we could share a version of that with you. However, that would not get you if you're required to consult. So and I should make this clear too, what we do is make recommendations. You are not allowed to violate the Endangered Species Act. Our recommendations are to help you not violate that act. The only thing you're required to do is to talk to us. Mm-hmm. You're not necessarily required to listen to us. That being said, that's what we have conservation officers for, things like that. We could enforce if we thought a take were to occur. But what we're making are recommendations to help avoid that from occurring. And what the requirement is that you talk to us. So it's probably more important, even if you don't implement all the things we say, that you would at least engage with us.
I think we just want to be following the rules
Sure.
and making sure that the people who are actually wanting to do these activities are consulting
Yeah.
with you
And
when
then,
they're
again, with
supposed to.
the zoning stuff in particular, it's really only when it's going from like an open land designation of some sort, where there's potentially, natural areas where there might be some of these resources to some sort of other type of development. If it is already a developed area, residential area, industrial zoned area or something like that, and it's changing, then you don't have to send it to us for those.
We have a couple more other questions in the chat. Mercy Davidson from Normal's asking for some clarification. She was under the impression this was only required for public projects, but it is for private projects too. So to your point, Brad, it's for mostly greenfield, or is it redevelopment as well?
It's for anything that, the requirement would be for any time there's a state or local government authorization, funding, or performance of that activity. So any private project that has to get a permit. So, and again, the requirement is never on the actual developer. I mean, you put that on the developer usually to do that work, to provide that to you. But the people who are required to consult are the state agencies and local governments, the permitting authorities, or the people who are distributing the funding, that sort of thing. So if you are funding a project that's, funding a private project for some, through a grant or whatever, they would need to talk to us. If you're issuing a permit of some sort, then in theory, you should be talking to us.
Or confirming that they are talking to you and getting
Yes,
that.
or confirming, again,
Yeah.
however you guys want to I believe that sometimes the agencies themselves prefer to handle that, and
Sure.
sometimes they say that you just include this in your permit packet.
Right.
Yeah.
So, for example, let's say you have a greenfield development, new culvers or whatever is going up by the interstate. It would be prudent for the city to make sure that that developer is getting the EcoCat and then submitting it. Or to your point, the city could be doing that, but
Yes.
it requires additional staff time on the city's behalf.
Sure, exactly.
But and it also doesn't take.
Yeah, and for again, they would probably need a permit from the EPA for doing that anyway. So so this is a newer thing that's happened in the last few years with the EPA. We have to go in to their system, their CDX system, where you submit your NOIs and for the permits. We have to prove that you have a valid consultation within the last 2 years. Same with SHPO, they'll do the same thing. So you're not going to get your permit from EPA unless you have that consultation letter.
Right. So, one, Mercy just followed up. Do we get an EcoCat on every new development? I was under the understanding also, if you do let's say an annexation agreement for 200 acres and you get an EcoCat at that point in the process, you had mentioned earlier today, the EcoCat's good for 2 years.
Mm-hmm.
So if you have a development within that 200 acres for 2 years, you don't need an additional EcoCat. You could get one, but beyond that 2 years, you would need an additional EcoCat in that 200-acre development, even if it's for 10 acres of that 200 acres. Is that accurate?
Yes,
Yeah, okay.
it's for the activity. And again, it's a little complicated because, like I said, the annexation itself is not an activity that may really disturb anything. It's the development that will happen later. And so we try to consider both aspects of that. And a lot of times, like you said, the development doesn't come for many years later. And then at that point, the developer is going to need additional permits. And at that point, they'll have to come back and provide more details on what they're actually doing. And we may get another consultation there at that point. Yeah.
So Mercy asked if Champaign gets an EcoCat on every new development. And yes, we do try to get, and like I said, most of the engineers are already doing it. So it's nothing more than just saying, hey, can you email me a PDF of the EcoCat? And usually within 5 minutes, they email it back to me and I put it in the file. And Mercy, I see your hand raised.
Okay, this feels so remedial. I'm sure someone else on staff knows about this and is doing it, but I've been here so many years and I have never had this conversation. So to anyone else on the call, I hope I'm not the only one, but
Well, that's
again,
why I thought this was a good session because I felt like most planners are not aware of this, and the city is the one that could be liable if there's a lawsuit. Like if there's an endangered species, an advocate for an endangered species, and they find out that the city approved this permit in the habitat area without the EcoCat, the city's the one that could be in trouble.
Right, right. And I think so. I wonder though, for me, for our community in particular, like Bradley, when you showed your map of like the pink circles that you had, and like it kind of looked like that was McLean County. Am I wrong? Was that McLean County on there?
I don't remember what it was. I think it was just
It
a
looked
street.
like McLean County,
Yeah.
and it looked like there was one pink circle anywhere near anywhere that I would be involved in. And so I wonder if it's like we like in normal, I should surprise no one. We're not famous for like endangered species
Yeah.
or like wetlands or like large natural areas. So maybe it's just the case that I've been practicing this entire time of my career in a place that just like this is just not going to be an issue or a conflict too
Yeah.
often. So
That's
feel
fairly
better.
accurate too.
Thank you.
That part of Illinois we just do not have. I mean, it's basically in the middle of a cornfield, right? So
we have
yes.
taken care of nature, indeed.
Yes. So
Okay.
most of our records follow if you are along a town, along a river, or in southern Illinois, that's where we tend to have a lot of records. We also have a lot in northeastern Illinois. They have a lot of forest preserve districts, things like that. And there's a lot of resources in those areas too. But
Brad, do you think those circles could change? Like, I was informed that the rusty patch bumblebee is an endangered species that, is locally present. Do you think that with either more analysis of endangered species that those circles would get bigger, or
well,
are they
so
really
how
static?
how that works again is we're looking at a point or a group of points, and we're just applying a buffer. There is potential that those circles could get bigger, smaller. It's very much kind of. I don't want to say they're arbitrary, but they aren't like every one of those are not based on science on that individual species. As we learn more about different species, we may expand. There's been talk with it's very much about what the future technology and what we can afford to do, changing how we map this stuff and maybe able to reduce the size of those buffers because we're grabbing the actual habitat more than just an arbitrary circle. It's just the best tool we have right now. There's nothing in statutes that says we have to make the circles, the buffers, any certain size. So there has been talk about increasing the sizes to capture more stuff so we can get eyes on more things. Just as a reference too, I mean, last year we sent out where we actually put eyes and sent a letter on about 4,000 projects, and we had about 15,000 come through the system. If that gives you any idea, sort of the ratio of how many hit a buffer versus don't, and the amount of traffic that goes through that website.
Oh, so 4,000 of the 15,000 hit a buffer.
Yes.
Oh, wow.
And again, most of those we say nothing. It's we just move it on. Yeah.
So did see a question in the chat. You mentioned, I mentioned that like it might be prudent to do it for an annexation agreement that's a large area, but you mentioned there's no actual development as part of that. Question came up about whether this is just for like like what's the gray area or the dividing line between when somebody actually would have to do the EcoCat, whether it's earth excavation or because you also mentioned some redevelopment doesn't need.
It'd be any activity that would change the existing environment. So earth moving would absolutely, and again, if you're disturbing more than an acre, that would trigger a permit with the EPA. So that often, and most projects do usually hit that trigger, most developments anyway. So it would hit that trigger, and we would, you'd need a consultation based on that. But yeah, but anything that would change that existing environment. With some grants, for an example, the times we don't review things, we get grants from HUD sometimes. Sometimes they're doing stuff outside, but a lot of times it's replacing windows or AC units or things like that in interior work. And we wouldn't obviously review that because that's not changing the existing environment. Or the DOT isn't required to talk to us if they're just remilling a road or pavement work. Now if they were expanding that pavement or new alignments, things like that, then that would trigger a review with us. Because it's disturbing earth, it's changing hydrology, all sorts of factors.
Matt, oh, go ahead, Marcus.
So answering Mercy's, comment, again, we thought we were dealing with this through our land development code, and properly dealing with it by including our soil and water conservation district staff. I uploaded a document in the chat after somebody else did, and it's labeled as a natural resource report from the Soil and Water District, which is the same terminology that was in the IDNR report that somebody uploaded right before I did. So maybe Soil and Water was overlapping with IDNR. Mine was from back in 2018, so maybe they were doing it and now IDNR is doing it. I've got no idea, but it'll be really good to work with Bradley directly and do what we're supposed to be doing, whatever that might be.
Frankly, it's hard to say how this was working before. It's there's been a lot of different captains on the ship here at this program, so over the years it's been handled differently. But I can say yes, statutorily it should come through us.
Okay.
Unless we have an MOU or some kind of agreement, which we don't within NRCS. So.
Brad, somebody in the chat asked to see a consultation or a consultation termination letter. I have one in a file that I'm just going to do a quick screen share.
Yeah, sure.
You can tell me, maybe this is an old one. Hopefully everybody can see my screen. So this was a new preliminary plat for a large undeveloped area, ended up being a church and then 34 single family homes. But, it's only 2 pages, says here consultation is terminated. So I just threw it in the file and essentially we were done with it. But the engineer on this one, Mark Miller, was the one that filed for it. And I don't know if it says what fee. It probably doesn't say what fee you paid on here.
If you paid a fee, there'll be a receipt at the bottom. But it looks like they chose EPA.
Okay.
Yeah, I could, and which is fine because they would have needed a permit anyway. And there was no fee paid.
And this was from 2019. And they still look like this?
Yes. And so this would be, again, this would be when we don't have any hits. You would get this immediately. You've done the process, you could move forward.
And that takes like 10 to 15 minutes for them to get that and turn it around, print it off.
That being said, I should mention too that we do have we can reopen a consultation based on new information. So if the public comes to us and said, hey, we've got things here that you guys weren't aware of, we have to address that. So you may have that letter and we could say, hold on, we have to reopen this. We've been presented with new information, and we need to reevaluate this. And then we could we have the option to do that. That does not happen very often.
Okay, well, I've not seen any other questions in the chat unless I missed anything. I would say, Brad, thanks for taking your time out of your schedule to speak to us, and really appreciate it. And hopefully moving forward, people are continue to get their EcoCats and being in compliance with IDNR.
Yeah, and I would say everyone, I understand our program and our process can be a bit confusing. So feel free to reach out. Happy to help. Send me an email, give me a call. We'll get you straightened out.
Awesome. Thanks, Brad.
Yep. Thank you.